The Answer online at 560theanswer.com, on the AM 560 mobile app, on your Alexa-powered smart speaker, and on TuneIn, iHeart, and on Odyssey. This is Chicago's Morning Answer with Dan Proft and Amy Jacobson on AM 560. The Answer.
Top of the morning, Dan and Amy. So the Daily Mail reporting yesterday that Trump is expected to be indicted today, although that's unclear if the grand jury in Manhattan will be done with their business, but that's the expectation. And that plans will be then arranged between the Manhattan District Attorney's Office and the Secret Service for Trump's surrender and appearance in New York City next week. He will not be arraigned this week, according to a source familiar with the proceedings that spoke with the Daily Mail. Yeah.
What's going on?
It's about to get interesting.
Sources are leaked everywhere. Even the Supreme, nothing's sacred anymore. Even the Supreme Court decisions are leaked.
Well, yeah, that's
this
the
our
case.
new world, right?
A lot of questions surrounding this, clearly, including whether or not even Alvin Bragg can get out of the starting gate and survive a challenge on the basis of the statute of limitations having run. So let's get into it with our friend Andy McCarthy. He is a former federal prosecutor, interestingly, in the Manhattan U.S. Attorney's Office for the Southern District. Also a contributing editor to National Review, and, of course, the author of the bestseller Ball of Collusion. Andy, thanks for joining us again. Appreciate it.
My pleasure, guys. How are you?
Good. So I know you wrote about it, but you're the prosecutor, so you explain it. There may be an argument to be made that the statute has run. We may not have enough information to know that, but for those who are just looking at the sort of 2 years for misdemeanor, 5 years for a felony, and the statute is run because the payment was made 6 years ago, it's not that easy.
Yeah, and I can certainly understand that because there's a lot of moving pieces here. But, basically you have a situation where Alvin Bragg, the elected progressive Democrat who is the district attorney in Manhattan, is trying to take something that is a misdemeanor that would never be prosecuted against anyone not named Donald Trump in New York, and not only bring a case based on it, but inflate it into a felony. And the consequences of that are multiple in the sense that it affects the amount of time he might be facing if he were convicted. It would be 4 years for the felony. It would be just a few months if it was the misdemeanor. But also the statute of limitations, Dan, as you mentioned, is different. It's 2 years for a misdemeanor and 5 for a felony. It's impossible to explain this without laying out a little bit of what the important facts are. Basically, the crime here that Bragg will allege is the falsification of business records. That's the misdemeanor. His theory for why that happened is simply that when Trump reimbursed Michael Cohen, who was then his lawyer/fixer, for laying out $130,000 for the non-disclosure agreement with Stormy Daniels. In fact, that was the payment or reimbursement of a debt that Trump incurred, a debt to Cohen in 2016. And the way they decided to reimburse that was to pay him monthly through 2017. When they booked in Trump's records the payment to Cohen, instead of showing it as reimbursement of a debt, they showed it as payment of legal fees, which, it doesn't sound like it's a big deal, but like for the government, it's a big deal in the sense that, for example, reimbursement of a debt is a non-taxable event. Payment of legal fees is a taxable event. So it could have had different ramifications, but in a nutshell, that's what he's saying the crime is. Now, the timeline here would be the payments to Cohn go from the beginning of 2017 to the last one. These were monthly payments, which happened on December 5th of 2017. And I presume what Bragg is going to argue is that gets him at least into 2018, because in 2018, that's when the tax consequences of 2017 are accounted for. So in other words, the 2017 records generate other records that you need to generate in order to close out the 2017 year. And if I'm right about that, let's say that the last thing of consequence that happened here was around tax time in 2018. That would have been 5 years, from April or so of 2018 would have been April. 5 years would be April of 2023, which might explain why you're seeing all this frenetic activity now, and why there's a sudden rush to indict this case. I think he's going to have a hard time, obviously, with the statute of limitations. But I think the more important thing, and I'm sorry to go on and on about this, but it's the only way to explain it.
No,
the more difficult thing
helps.
Yeah, the more difficult thing for him is the statute of limitations is problematic enough, but even more problematic is the idea that this was a felony, because in order to inflate that misdemeanor into a felony under New York law, what he's got to show is that Trump, in falsifying the business records, intentionally attempted to conceal another crime that he knew he was committing. And I think it's going to be hard enough for Bragg to show that Trump even falsified the records, because I don't think that was his job at, accounting at the Trump organization. He may not have even known how they were booking this. He may have known, he signed some of the checks, but he may not have known. But the problem with the felony is even people like me who've been lawyers for more years than I care to admit to are having a hard time trying to understand what other crime Bragg is talking about here, like what other crime lurks here. Been a lot of talk about campaign finance violations. I don't think it is a campaign finance violation, and even if it were, when New York law talks about concealing another crime, it has to be another New York crime. It can't be a federal crime, and the campaign finance violations in connection with presidential elections are federal, not state. But even if I'm wrong about that, and Bragg has some crime that he can show was somehow lurking underneath the falsification of these records, the problem he has is that he's got to show beyond a reasonable doubt that Trump not only knew this, but consciously acted in a way to conceal that other crime. And I think the best interpretation of what happened here is, if he's responsible for falsifying the records, he did it for the same reason he entered into the non-disclosure arrangement in the first place, which was to keep it from Melania, that he was entering a hush money arrangement with a porn star, and to keep it from voters before the 2016 election. Now, those two things, you may think they're disreputable. I think they're disreputable, but they're not crimes. And what Bragg needs is a crime. So I just don't see this case.
Now, one point out that CNN Van Jones talked about, he said, why rush to this? Why should we start with Georgia, where he was interfering with elections? Why is Bragg doing this? So even the left is saying why is he doing this? Is it all political to elevate Bragg's name maybe to the national spotlight so he can run for higher office?
Yeah, Amy, I think there's two things on that. First is the thing that we discussed earlier in our conversation, which is that the clock may be ticking on Bragg. In other words, if he doesn't bring it now, he may lose it.
Okay.
He may be on the outer ring of even his version of what the statute of limitations says. But I think the other point is one that we miss often because our media coverage is so Washington-centric. We're so focused on the federal government. In the federal system, prosecutors, U.S. attorneys, the attorney general, they're appointed by the president and they're vetted by the Senate. And at least the vetting process is supposed to make sure that they're not going to use their law enforcement power as a political weapon. And if they do, they could be removed, right? In the state system, it's very different. In the states, politics pervades law enforcement because these district attorney positions and state attorneys general are elected politics positions. So, for example, Bragg ran, just like Letitia James in New York, the state attorney general. They ran on the idea that if they got into power, they were going to use their authority against Trump. They used that as a political issue. So I think, we're much better, and we'll probably analyze this all a lot better if we look at Bragg not as a law enforcement official, but as an elected progressive Democrat who was doing in office what he said he was going to do when he got elected.
Another matter there's news on that relates to the investigations and perhaps forthcoming prosecutions of the former president. And that's with respect to the special counsel on the handling of classified materials. Right. The ABC was reporting yesterday that a retired U.S. District Court judge wrote last week prosecutors in special counsel Jack Smith's office had made a prima facie showing that the former president had committed criminal violations, according to their sources, that he deliberately misled his own attorneys, did Trump, about his retention of classified materials. Well, one, just your underlying assessment of the importance of that leak, and then two, on here we go again, Mueller 2.0, with things leaking out of the special counsel's office.
Yeah, I think this goes, Dan, to what I said about the Mar-a-Lago documents case. Once we got the revelations that Biden also was a serial hoarder of classified documents. Mm-hmm. The special counsel may have a lot of evidence that Trump retained classified documents illegally at Mar-a-Lago, but the Biden revelations, especially after the Justice Department let Hillary Clinton off the hook for an egregious violation, they made it politically very difficult to bring a documents case against Trump. So what I argued when the Biden stuff came out was that what you were going to hear now from Democrats and the Biden administration and the Biden special counsel was the Mar-a-Lago investigation is no longer really a document retention case. They're going to say it's a grand jury obstruction case because that's what distinguishes the Trump situation from the Biden situation. And if they just tried to indict him straight up on retaining classified documents, then Biden would have a problem, right? So they completely changed their emphasis here to grand jury obstruction. Why is that important? Because the lawyers who were working for Trump, including this guy Evan Corcoran, who was the subject of the order that you're talking about, he represented when the Justice Department issued Trump a grand jury subpoena requiring him to turn over any documents marked classified that were in his possession. Corcoran basically took the lead in producing that and had conversations with Trump about what was produced. And then in June of 2022, they produced 38 documents, which they said was all of it. They said they had done a thorough search at Mar-a-Lago, and this is what they had. And, of course, we know that like about 6 weeks later, when the search was done, they found over 100 more. So the theory here is that Trump misled his lawyers into misrepresenting to the grand jury that all of the documents had been turned over in June when, in fact, he was still hoarding them.
Right. And so
that's what this is about.
How do you distinguish that from Biden? Because Biden, because he just said, "Come on in," and even though they were producing documents, they were producing documents. Well, come on in and look yourself, and then they found more documents. Ostensibly, when they produced documents, said, "Well, this is what we have, and this is all we have," and then they found more, and then, well, we have more, and then they said, "Well, if you want to come in, come on in." I mean, how those are sort of a distinction without a difference. We're representing that this is an exhaustive search and these are the documents we have that you should have, but then we find more and then you find more. And so, I mean, in the Trump case, possibly he was directing his attorney or misinforming his attorney. And it's also possible he was like, yeah, I don't know, whatever, go through the boxes, whatever's classified, whatever they want, give them, don't give them this, give them that, whatever. Like he's, so, I mean, we have no idea what the conversations were. And it seems to me that this leak is, to your point, about setting up that the setting up the media to make the distinction you were just making to try to sell the public on prosecuting Trump for something very similar to what we understand Joe Biden did.
Yeah, well, I think that's what the messaging has been about ever since we learned about Biden. But to go, you mentioned the judge who issued this order. Now, we haven't seen the order, right? This is the subject of leaks to ABC.
Right.
But the judge in question, she's not actually retired. She's stepping down from being the chief judge of the district court in Washington, and that's just because they rotate position.
Right. Okay.
But her name is Beryl Howell. More important is like who she is, right? Yeah. She was Pat Leahy's warrior on the Senate Judiciary Committee. So she was appointed to the bench by Obama. She's not exactly Trump friendly, as you might imagine. And this was her parting shot. The reason the District of Columbia has some interesting local rules, and one of them is that the chief judge handles all grand jury matters that come up for litigation. So that if something comes up where, the grand jury is trying to get something, somebody doesn't want to turn it over to them, that goes in front of the chief judge in cases in the District of Columbia, which, by the way, could very well be why special counsel like Bob Mueller set up shop in Washington while, Chief Judge Howell was there to make all the rulings. So she's now stepping down, and a different judge will be taking that role. This is her last, probably her last ruling in the grand jury connection. And what she said was that Trump was, according to what we've seen, we haven't seen the actual ruling, but what's reported is that she said that Trump was involved in a scheme of obstruction to retain documents that goes back before there was a grand jury investigation, when he was apparently misleading the National Archives for a year about what he had retained and whether he would give it back and all that stuff. So what she's saying is that there was a pattern of conduct for 18 months or close to 18 months by the time Evan Corcoran and another Trump lawyer named Christina Bobb represented to the FBI that they had conducted a thorough search and that these 38 documents were the only ones left.
But we don't know. And on what basis does she make that conclusion?
She's looking at all of the correspondence between the lawyers that Trump designated to deal with the National Archives and the lawyers of the National Archives who beginning in, I think, January or February of 2021, tried to get back reams of documents that they understood that Trump had.
But communication between Trump and his attorneys is privileged.
Well, this is what the upshot of the ruling is, that the attorney-client privilege is pierced. That is, the communications are not confidential if they are in connection or they're under what's known as the crime fraud exception.
Yeah. Right,
to the attorney. So if the communications are in furtherance of a criminal scheme, and here what they're saying is it's a criminal scheme to obstruct the grand jury, then they lose their confidentiality and the prosecutors can get them.
Well, but I understand the crime fraud exception, but how do they bootstrap to conclude that the exception is applicable?
Well, I guess what they're saying is that there was a grand jury subpoena that demanded that they turn over all of the documents, and they said that in lieu of a grand jury appearance, they would take a sworn statement saying that all of the documents they had done a thorough search and all of the documents had been turned over. So in June, they give them a sworn statement, which is supposed to be communicated to the grand jury, that says we've done a thorough search of Mar-a-Lago and these are the only remaining classified documents. So what they're saying is that was a lie to the grand jury because that was the circumstance.
But how do you?
I don't know.
We go back and forth. How do you establish it wasn't just a good faith mistake? You know what I'm saying? I mean, that seems
like. Well, that's what a case is about. Let's be clear. He hasn't been charged yet, right? So what happens in an investigation is you have evidence that the law was violated, but you don't necessarily know that you can prove it until you figure out can I prove all of the acts that are necessary to establish a crime? And as you're saying, can I establish that the person I want to charge had the intent that's necessary to commit it? So far, they haven't charged him, but, you build a case a brick at a time. So that's what they're trying to do.
He is Andy McCarthy, former Chief Assistant U.S. Attorney at the Southern District of New York, contributing editor at National Review, author of the bestseller Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. Andy, thanks as always. Appreciate your insight and expertise.
My pleasure. Have a great day.
Thanks, you too. And he joined us on our turnkey.pro answer line.
This is Chicago's Morning Answer.
Your show keeps me alive during the week. There's nobody I'd rather listen to between 5 and 9 in the morning than you guys.
On AM 560, The Answer.
Have you been struggling to find an easy, safe, and secure document scanning solution for Salesforce.com, Microsoft 365, SharePoint, or OnBase by Highland? Your struggle is now over, and it's time to get your